Yes, sir.
No, please wait for him to finish, then you can proceed.
Honorable Chair, the issuance of the certificate of title on 11th October 1994 does not reflect anybody who was issued this certificate of title. It's blank.
Now my question is, if now there is nobody whom the certificate was issued to, why did the custodian board went ahead to gazette and certificate withdrawn, that this certificate was withdrawn? So he was withdrawing it from who?
Honorable Chair, that could show that there was an irregularity. Then also, Honorable Chair,
Honorable Mayor.
Mr. President, you see, what we want, special certificate is issued by an instrument. That means there was an applicant. The commission should not sit in office and issue special certificate. What do you want to do with this committee? Take us to positive answer on the record on who applies a special certificate. So we're going to try with a candidate, no, that way again.
Honorable Chair, given the record on the copy of the title we are having, it implies that it is a mere investment applied for the special certificate.
No.
Because there is not a
This is fine. We are not here for a drama. I don't want to come here for imagination. What I want to tell us, this property was vested under custodian board. Is it true?
Yes.
Yes. How did it got transferred to Mera Investment?
We don't know.
What is the effect of that?
The register on this title falls.
Lady
It
Council.
must be cancelled.
Lady Council. Proceed. And who?
Mr. Chairman, I'm wondering whether it's not considered right that as a committee, we write to the Commission on Land Registration to give us this instrument which is entitled, because there's an instrument book where actually the applicant, there is an instrument which is an application for registration. It must be in the record of land, so that we know whether it is very investment or in another person. So that's how it will make us believe.
Mr. Chair.
Mr. Chair, thank you. Thank you, Mr. Chair. In his own words, the chief executive, the ED, I said that the minister wrote a letter of authorization in 1993 for repossession. I think all the details are enclosed in such a letter of repossession. And to Mr. Chairman, let us protect the ED, because we came here for information and we asked him for information. And if that is what he's telling you, that I don't have the name of the title, he has told you that it is Mera Investment that applied for it. So let us take that on record, because that is his own.
Members, the reason as to why we need to interrogate the executive secretary more is it's not about getting the surface of the information. We need the detailed facts, because the witness has presented his documents as a fact. So we need information where it shows that now the witness, according to you as custodian board, if the property is yours, the one who did repossess, we don't know who repossessed, according to you.
Honorable Chair, I'd like to refer to this honorable committee to Section 7 of the Expropriated Properties Act. Transfer of title. A certificate issued under Section 5 or 6 shall be sufficient authority for the Chief Registrar of Titles to transfer title to a new joint venture company or the former owner as the case may be. 2B. The bank or financial institution to reactivate any frozen account or repay any transferred monies. C, the registrar of companies to reinstate on the register a company that had been struck off.
Mr.
My
Mayor,
implication,
just a second. Don't want to go around in circles. We are handling repossession and transfer of title. Okay? Let's start from what, so that everyone understands.
much obliged.
All right? What you're reading before us is what has been presented and what you have. Let's go question by question. Let's talk about repossession, okay? What would we call rightful repossession? When someone applied in time, is that true?
Correct.
When did the former owner of this property apply for repossession? Which year? Let's move systematically. If you answer those questions, we shall arrive to how it was transferred to X. There's somewhere you read with the receipt and
Actually, Hussein Nazarari,
when did he apply? You read already.
this is on 19th May 1983.
So he applied for repossession within time.
Yes,
Very good. 1983.
83.
So the repossession was within time.
Yes.
Okay? Now, there are two questions that follow.
You asked the question, Honorable, you asked the repossession. The process of
So
repossession.
you told us that they repossessed out of time. Now we are interrogating your word.
I have not said that.
So do you challenge the process of repossession?
Yes,
Why do you challenge the process of repossession?
it wasn't completed.
It wasn't.
Completed.
What amounts to completion of the process of repossession?
The issuance of a certificate of repossession by the minister responsible for finance.
So are you saying all properties that were repossessed by later were illegally repossessed?
Actually, a letter is not provided for in the law.
Let's go slowly. You've been here on different properties before. Are you saying that all properties that this committee, because your submission should be that this committee should declare, or in its findings, because you're giving us your findings, that all properties that were repossessed by later were illegally repossessed? Is that your submission?
That's my submission.
Has your board, you've been sitting as a board, have you ever brought this under your minutes before the board, to the attention of the board? So many times. Honorable member, why I'm moving in this order of chronology? Because we may not need to even need submissions for other properties. And no, that's what I'm saying. Because if he says all properties repossessed by later, in his opinion, were illegally repossessed, we have in the list of the properties he submitted to us, we have properties repossessed by later and properties repossessed by
Procedure takes precedence for Itongo.
Chair, remember your communication that this was a matter that started around January. And why we are not handling this matter is because we wanted to hear the side of the story, the other side of the story, in case the custodian board gives us the other side of the story. Now, according to the custodian board, what they are submitting, if we are doubting what they are submitting, if there are some hiccups in what they are submitting, and the good news, Dr. now is here, why don't we allow the custodian board to finish his story, and then we allow the doctor also to give his side how we are investigating came in, then we make opinions as members.
And information, Chair, I remember very well when we invited the custodian board, the Minister of Finance, who is the chairperson,
mentioned it clearly before the committee when he was differentiating between the repossession letter and the repossession certificate, where he was saying that for one to repossess the property, it must be through the repossession certificate. It's on the record.
Now, my question, before you come in to Executive Secretary, if you say that this property was wrongly repossessed, have you ever brought it to attention of doctor or to Mera Investment that this property which you are having, it has a problem with custodian property?
Honorable Chair, Honorable Chair, this whole committee handling these issues is out of the Auditor General's queries, and which is an ongoing process. Honorable Chair, you will recall with the honorable members, we have gone through tripartite meetings to handle this issue. This can't be handled personally. This is a situation that has stayed on for some years. Actually, we are now trying to do some forensic audit. As for the Auditor General's report, we are supposed to give a comprehensive report. And as of now, when I came in this office in 2017, these are the issues I have started on, and it is a gradual process.
You see, Executive Secretary, the legal counsel was asking for the process. In your submission, you say the process was never concluded. Was never concluded. So we want to start from there, and you conclude on that. We proceed to another property.
Chair, as he's coming, still on the repossession. We see this property was tenancy in common. The first half with about 3 people, then the second half with about the same number, I think around also 3 people. Where Hussein Nazarad was one of them. One question to you, Mr. the Executive Secretary. Did the Nazarad Hussein have powers to repossess the whole property in case the application had succeeded?
No.
Why?
Why?
Because he had no legal nexus for both.
So, lastly, on the same, why did you went ahead to gazette this property and the certificate withdrawn? If you had not issued a certificate, you know very well you didn't issue a certificate. Why did you went ahead to gazette that this certificate was withdrawn? What were you withdrawing?
Actually, since this was the Gazette of 1991, I needed to go to the archives and find out. That as it defeats your actions, it also defeats us. And that's also, it shows the illustration of a planned fraud.
Have you ever brought to Dr. Mera's attention that that property belongs to Custodian Board?
Yes, that's why it's here.
Do you have evidence on that?
That's why it's here. And by the way, this information you are using, some of it is from Custodian. Mr. Rizzo, I want to help this committee to understand, for your own benefit, as Executive Secretary of Custodian Board, for the benefit of Mera Investment, who now holds the title, to know their stand. It's not about now drama, or it's about who will win. It's not about that. We need to know exactly. Honorable Chair, have you ever written to Mera? Because in several occasions we have letters on some properties. On some no, the question is, in several before the committee comes in. There are some properties where they have written to individuals that this property belongs to Custodian Board. But now, in this aspect, have you ever written to Mera Investment that the property you are holding really belongs to Custodian Board? No, we have not.
Let's proceed.
Thank you very much, Mr. Chairman. And that's where I was going, by asking you to show us a board minute. Because if you dispute and you know it belongs to you, the first is to instruct your lawyers or their committee to write or challenge it.
Honorable Chair, as I can submit this honorable court, even to this honorable committee, that getting this information, it is an effort. Like I got this copy of the Gazette from Makerere University on 3rd May 2018. And this was the result that some of the information as we talk is not in the concerned board offices. I'm getting it from whichever source. Now, after getting such information, there is no need to hurry. We need to handle a systematic process. That's how this issue now is to this committee, which is an accountability committee.
So, members, I think the onus is on the conclusion of this goes to the committee. We shall get all the information we have got before. Then we'll, in our report, we shall write our findings on this. However, if my last question from Custodian part, my last question to Doctor, my last question to Doctor, if you can help this committee, whom did you buy this property from?
I bought this property, the documents are attached to we bought it from, and to all the people who have been in the register for private. If you look at the last 3 pages on the appendix here, this was also witnessed by Justice Ivan Swata, who was a lawyer then. So working with Sudhir and Company advocates, who's the judge now, who was a witness in this transaction.
Who did you buy it from?
Chairman, the people I bought was from Anwar Ali, Muhammad Ali Alibai, Mustafa Ali, Muhammad Alibai, and Hussein Hassan Ali Jamal, and Ghulam Bas, Nazar Ali Jamal. Their family also. If you look in on the second page, signed by Anwar Ali, Muhammad Ali, holder of a very powerful attorney, registered under so and so. It was presented by Dr. Ham Munira and Company.
Custodian board, would you be knowing those people who sold the property in your legal file? Yeah.
Those who are not in a way near the owners of the property. So that is another transaction.
So I would direct you to give me a detailed narrative on that plot. We go to another plot.
Chairman, even if you look in the title, the same people who sold me are registered proprietors.
So on that, we shall make our informed review when you give us the full narrative of the property of what you have. Then we shall compare with what doctors submitted, then you can proceed.
With your permission, I'd like to bring to you something that I'd like to discuss. First of all, there's a Supreme Court authority which says a letter of authority is the same as letter of repossession. Repossession is the same as certificate of repossession. This is a Supreme Court authority. Can I finish?
Please, members, leave doctor to present. Then you come in. If you have a question to ask, you'll come in and ask. He's here.
Chairman, this is a Supreme Court authority. The letter certificate of repossession is the same as of repossession.
There's another authority which says that once certificate of repossession is issued, the custodian body has no authority to cancel that.
But doctor, I know that in making the
I'm just bringing to your notice whether you want to take it up or not, it's up to you. But these authorities are there. And thirdly, all these things were registered proprietor more than 12 years. It is even outside the statutory limit. I just want how you make your report is up to you. But
you see, doctor, expropriated properties, they're not like a RTA. In RTA, good enough I have my teachers here who told me I'm glad to see them here before me. I see Council Sudhir, Council Cosase. But the laws governing the RTA, that's not the laws which governs expropriated properties.
Information, Honorable Chair.
Thank you, Chairman, but I'd like to give you the same constitution.
Honorable Chair, the information I'm giving, since the doctor is quoting a Supreme Court authority, we have one, Honorable Charani Awaliji, and Brett Chamakola Olveta, Appeal number 4 of 1995, the Supreme Court. It quotes, no act can be said to apply on any expropriated property until the minister responsible for finance has dealt with the property. Further, another Supreme Court authority is under holding Mazuri versus Singh Baram, Civil Appeal number 9 of 2001. Court held, and we quote, no expropriated property can be violently sold by the former owner, not even just any other party, before repossession. A dealing of whatever kind in such a property is an active sale and can only occur after repossession with the consent of the minister. Because I had to say, Honorable Chair, to our understanding, this means that the repossession, certificate of purchase, or receipt of property under the Act can only occur after the minister has dealt with the property. It should be noted, Honorable Chair and members, that the leases on this property stopped running until such a time when the minister responsible for finance deals with them by issuance of a repossession certificate, certificate of purchase, a receipt, or donation. Honorable Chair, sir, I further want to summarize here by saying any property under Section 2(1)A and Section 2(2)(1) and B, any property or business which was vested in the government and transferred to the Property Custodian Board under the assets of Agency 1973 shall, from the time of commencement of this Act, remain vested in the government and managed by the Ministry of Finance. Yeah. 2. Honorable Chair, if I could conclude, just one other phrase. For the avoidance of doubt, and not withstanding the provisions of any written law governing conferring of titles of land, properties or businesses, and passing or transfer of such titles is hereby declared that any purchases, any purchases, transfers, grants, or any dealing of whatever kind in properties or businesses are hereby nullified.
Thank you for that.
That's Honorable Chair.
Okay, we have to go to...
Honorable Chair, this is very important.
Just a second, Honorable Chair, procedure maybe. Attach your submissions, whether based on law or facts, on your submission.
Much obliged.
And you, if you also have your authority, like you stated, attach it. We as a committee, we shall sit back and write a report.
I therefore on that direct the Custodian Board to give us a full narrative of Plot 38, Kampala Road, and the photocopy of the original file with all the narrative on 8th July 2020, submitted before our clerk. Next.
Chairman, our witness refer to power vacant in the annex of Plot 38. You don't attach it. Because why you say we derive the, we also derive the authority to say, and rather they mind the function has to the people of power vacant. Because what gives the authority in the people who live in the property. Rather, if they give us the power vacant, it would make the resolution is complete.
Honorable Mwilo, being that We have ruled on that, so we will ask them to also provide the relevant paperwork and everything which they got from the person who sold you, which you stand in to know that this person really owned this property. Yeah? Members, planning issue, we are going
So we have just received these documents, and when I'm perusing these documents, the statement here says that looked about from the number of parties. But when you look at the same agreement, it's only one person who signed for only two parties, the other parties are not represented on the same agreement. So we want to know, now that we have these documents.
So those are the documents we are requesting Mela Investment to submit before this committee on 8th July 2020, so that we get to know. Members, we're going to try to make our informed view when we have all the documentations.
Yeah, but Mr. Chair, here you can say we didn't give you. Chair here, he is here, he can explain to us. He has not objected.
Chairperson, these are not power of attorneys, are not document, they're registered. They're registered.
Microphone, Doctor.
Chairperson, first of all, power of attorneys are not my documents, they are documents of the seller. And so, you know.
But Doctor, in doing your due diligence before you buy a property, how did you ascertain that this person who sold you that property, indeed, was the owner of the property?
You said they are not your documents, that they are documents of the seller.
Because by the time the person sold you the property, he gives you all the documents to show that the property he has sold to you really belongs to him.
They should be available to the attorney.
So that's what I'm requesting, that you will submit all the relevant documents to show that the person with whom you bought that property from, indeed, he was the rightful owner of the property. Putting in mind that you have heard what Custodian board they have presented and what members they have presented. So you submit those documents on 8th July 2020, next in council.
Whatever the position
Please, let's move on.
Just a second. Thank you, Mr. Chairman, for your wise in this matter. Please help us, like you said, for the balance of opinion, that you submit anything giving you nexus to the property, and that will be the powers of attorney, giving the nexus of someone who sold it to you, because their challenge is that they don't exist. So your issue is how do you get into this? It's the POS. You attach them on file. If you don't have them, let these council that represented them furnish us with the POS. Thank you.
Next. The reason why we are saying that, we might say that you rightly bought the property, but even me, I can steal a car and I sell it somewhere. So this one is on your own interest to furnish us with all the issues to make exactly how we transfer.
all the properties listed here, considering all the never written to us. One letter, not only this property, but every property mentioned here.
That has been captured. We have noted that, and it's not here. We can't make a judgment here. We shall write our report and based on what we have heard.
And next is Road 24, Kampala Road. Maybe you can speak to the documents that you've given us. Attached, honorable members, the one with the yellow paper. Next be. So please go ahead, then we shall hear from the Custodian board. Then you leave us to, when we're writing our report, if you require any other information from you, we shall ask for it. All right.
Thank you, Honorable. Road 24 Kampala Road, please switch on your Road 24 Kampala Road, the following documents enclosed as Annexure B. Such report showing Vera Investment as registered proprietor. The freehold after conversion. There is a court ruling dated 28 December, FDCCR number 116/2012. In the matter of judicial review, rule statutory instrument number 211 of 2009, and in the matter of application for judicial review, Mira Investment Limited versus Departed Asian Custodian Board. 4 leasehold volume showing Mira Investment Limited as the buyer. The matter was conclusively determined by court of law.
Custodian Board. Custodian Board. Voting.
Honorable, this matter has been conclusively determined by court of law. Thank you.
Honorable Chair, I would like to submit. I'll first of all give the President the chronology of this property. This property was co-owned. Half of the shares by Ramesh Chandra, Bhuvan Katria, half divided shares alongside Karaswali, I don't know this pronunciation. This property is still vested in government under this city. How the same has not been validly deposited. The former owner, Bhuvan Kataria, and the RP share, who owned the property initial shares, never returned. There is a letter, proof of a letter expressing the possession and certificate number 2391 because of the property. However, we note that on 5th April 1995, the one Martin in Kutu, care of Snoopy in Soke and Company Advocates, PO Box 3213, telephone number 233204 Kampala, picked the certificate in possession, but on the record, there is no dot of authority attaching the position process. Let me look my further submit. And it was gazetted for sale in one of the instruments of 1995.
Honorable Chair, as my chairman, the Special Committee has submitted, this was a property which was co-owned by 2 people, a half undivided share, and another half by Karashava and Ramesh Chandra, respectively. According to our records, it is only one share, half share, that was repossessed on that property. Then the other half share was never repossessed because the repossessor, the proprietor then never returned to physically operate as per the law. And it was found out that Mera Investment, when he was titling what he had bought from the repossessor who physically returned, he also enjoyed the other half, which was supposed to be for Custodian Board. And also on record, we have it that under a judicial review, this property was solely given to Mera Investment, which, according to Custodian Board, we requested the Solicitor General to give advice.
Do you have evidence on that?
And share that, and
you submitted to the police?
I shall.
Maybe the question that is simple to that, because you're a body that can sue or be sued, all right? Is that true? Is that a matter of fact by law?
It's a matter of fact.
Did you appeal? Did you even put in a notice of appeal of the decision?
According to the report here, the Solicitor General was notified. And
the question is, did you appeal? You don't need to seek clearance to appeal from the Solicitor General. Did you appeal?
I will share. I didn't submit.
Because you see, the Attorney General is part of the board. The Departed Asian Custodian Board is a member. So when you write to the Solicitor General, you're writing to the Attorney General,
who is already party to the suit.
I request.
So just answer the question, and then you give. Did you appeal?
I request this honorable committee, some of these questions which are pertinent, they are misdirected. Like you made a submission to the Solicitor General. Actually, it is incumbent upon this committee what happened.
You see, the Solicitor General is part of your board, and you're the executive secretary of the board. Just a second, go slow. Maybe let me put it clear for everyone to understand. We are not saying you are at fault. We are only saying we want to arrive to the best decision to give justice to you and to the entire country. The Attorney General and the Solicitor General is part of your board by virtue of being below the Attorney General. Is that right?
Correct.
That is correct. And they even attend certain meetings of yours of the board. Is that correct?
Correct.
So, did you say you brought it to their notice, and the chairman clearly asked that, do you have proof of that matter, and you said yes.
Yes.
And the question we are only asking you for our consumption is that, did you appeal? Or take, because appeal starts with the notice, and then you can go ahead to do the rest. Did you make an attempt to appeal?
With due respect, I still request that that question be given to the appropriate.
To the Solicitor General?
Yes.
Not to
Not me as a
No,
chairman.
please, Mr. You sent any representative in that matter to represent Custodian board? Who went in court to represent Custodian board in that matter?
Honorable Chair, if the party doesn't vote Custodian board as an institution under Minister of Finance, we are obliged to be represented by the government lawyer in the Attorney General.
Did your government lawyer went in court to represent the interests of Custodian board?
At the preliminary stage, yes.
Then, at the last stage?
That's why I would say that there is a submission on the file. Then it is also incumbent upon this committee, because this is an accountability committee.
Mr. Chairman.
Mr. Rizzo, we are talking of government property. We have all the mechanisms to represent the government property. I don't want a situation where I would think that maybe you are lying with this committee. So, if you knew you had a case in court, as Custodian board, did you follow up the case? Did you send your representatives? When you got the judgment, because that issue of saying, yes, there is a judgment here, we dispute the judgment, but you did went ahead to appeal.
Mr. Chairman.
Honorable Muiru.
Thank you, Mr. Chairman. I think Mr. Rizzo, the witness before us is saying that this matter is just to the test. You cannot open it up without going to process of appeal. And the chair's question is, when you lost the matter as a department, when you are giving instruction to Attorney General, there is a form you fill in the government giving instructions. Did you fill a form instructing Attorney General to appeal against this decision?
Yes, that one earlier on.
And what evidence is? Because that's the evidence of one. Because that we know, that maybe people that Attorney General has slept on job, but on your part, you are trying to do something.
Can you submit it before this committee so that we can peruse and appreciate your submission?
Mr. Chairman.
Honorable Chair, I have a document of 2012 that I think is submitted.
Please do submit. Honorable Kahonda.
Thank you so much, Mr. Chairman. Mr. Chairman, this is not the first case we have handled here. And I think the issue of court ruling and the representation becomes secondary. Our primary objective here is on the repossession. Was the property rightly repossessed? That should be the issue of the matter. And then the issue of court, their investment versus Custodian board, whether they appealed or not, that becomes second. The information that we should first get is whether the property was rightly repossessed.
Mr. Chair.
And maybe one question to the custodian board. You said if the property is jointly owned, one person had no right to repossess. What would be the right procedure of repossessing the property when that is jointly owned?
Members, I think that one we have exhausted it.
No.
Mr. Chair.
We haven't.
Chair, can you chair for everything concerns Mr. Chair?
From Itungo, then Honorable Panado, then Honorable Sonia.
Thank you, Chair. Chair, I'm saying that we have people from Custodian Board as a committee which has been going through. But this morning, doctor has submitted a side of the soil as far as properties are concerned. And the doctor from the submission, in the first property, you attached the sale agreement where you bought from. But for this second property, property number 24 Kampala Road, I don't see a sale agreement attached on the annexes you have given us. So I would be interested to know whether you have a sale agreement for purchase agreement for this property and what is there attached to the record.
You see, Honorable, okay, you submit, then I will come.
Thank you, Chair. Today, I will cover this regard of my colleague was saying that this regard the evidence for the court considering court had made a decision on this. If the court had made a decision on this, it had its merits and what weight and factors about it. Maybe now it moves back to me as a committee, maybe some of the questions being posed to Mr. could be questions of the Ahmed to perform our decision, and then maybe we call the Ahmed to come and answer some of these questions.
First of all, to my colleague Kahonda, Parliament has no powers to review what decisions. That powers we don't have it. We don't have it. That one we don't even argue. That's a fact and matter of law. We don't have that right. However, what Honorable Sonia, you first submit and I will submit.
Thank you, Mr. Chair. Honorable Kahonda's point is that it is not the first decision we are going to do this, to delve into matters that have been already decided by courts. Because this is a matter of our report. We may end up handling issues, like 20 of them, which have been decided by court. There is a tendency where when Parliament starts on an issue, then people want to stop our work. Then we might end up without doing anything.
Honorable Sonia.
On several occasions, we've been delving into issues, at least not to get information. And then what happens to our report will be something else that we have to know and understand, like you are saying.
Honorable Sonia, the principle of separation of powers. Normally, we have been proceeding with matters. If we start up with the matter as a committee and those people run to court, that is totally different. Than here, they went to court first, they got the ruling. Custodian board never bothered to go to court to defend their interests. Even after the judgment, they did appeal. When you look at what Executive Secretary has presented before us, I want you members to know, to tell me whether this is a notice to appeal, because it's a letter dated 16th October 2020, Remiscellaneous application number 837 of 2012, Mena Investment versus Departed Asian Property Custodian Board. Please, they were now the Solicitor General, Minister of Justice and Constitutional Affairs. Please refer to the above mentioned subjects. We have today, the 16th October 2012, received a letter of the same date advising that the subject application is due for hearing on 17th October 2020 at 2 p.m. We received the same under protest because of the short notes given. A certified copy, photocopy of the notes is attached herewith for your perusal. Yours faithfully, Sam Malay. Executive Secretary. Is this the notes? What narrative? If I may read the narrative, this is Custodian Board, Plot 24, Kampala Steel, still there is, I think, run for 99 years, but letters of administration. Application for judicial review, mail investment, was an interim injunction order issued over this property on the 5th October 2012 and expiring on 7th October 2012. The solicitor to be availed with his interim order and a brief only.
Mr. Chairman,
This is not the.
Chair, that is a narrative that was written to the Solicitor General for his address.
Now,
there is also another communication to that effect. By the way, if this committee, an accountability committee, if it is of your help in these issues, we will be asking ourselves, does a judicial review give ownership?
you see, that one, you can only ask that question if you had gone to court and challenged that on appeal, which you did.
That's why I'm saying, Honorable Chair, that issue is with the Solicitor General.
Let me help you. Mr. Chairman, thank you very much with your leave. Comrade Mr. Bizibu, that's why we asked calmly, does the Solicitor General form part of your board? The answer was yes. Do you have regular meetings? The answer is yes. Okay? Have you brought it to his attention? The answer is yes. Has he appealed? We want the answer. It's a yes or no. And it's only being honest. We don't want more. We shall make our findings as we are writing the report. We are not shifting blame on you. You may not have that technical ability to see whether you make an appeal or not. And we are not putting a blame on anyone. We are only saying we shall even invite other parties who did not perform their duties as called upon by law. But a decision of court, even if it's a judicial review decision, in administrative law it's very clear. All lawyers are here and will tell you when a decision has been reached at by court, Parliament cannot review it. The issue is you sit with the Attorney General. The Attorney General and Solicitor General, if they thought that the decision was wrongly arrived to, they would have appealed. And we as an accountability committee is to ask you, the monies we appropriate to Custodian Board, where was the problem? Do you lack lawyers? Do you lack the money? Even to write, because of the first property, the issue was to write, to say we are not comfortable with your ownership. Was there an absence of stationery ink? What is the problem?
Members, I don't agree with the Lady Council saying we don't blame anybody. We have to place the blame to Custodian Board and the Attorney General's office. Because this is not the first case. There is just a recent case before Justice Sekana, where you knew there is a case, you did send any representative, and Custodian Board is supposed to pay. And the issue is you didn't have any representative. What did you want the judge to do? The same in this. Yes, you have discovered the lacunas in the judgment, but how are you going to remove them? By just sitting here in the committee and you say there was just judgment, judicial review doesn't give ownership and we lament?
I'm humble submitted that some of these questions
you see, Custodian Board, I want you to accept you still have a weakness and you have made the government lose a lot of money. Even the just concluded case before Justice Sekana, you lost that case because you never went to court to represent, to defend the property.
Chair.
Honorable Itungo.
Chair, my issues on the submission of this document from Doctor. Doctor, this document we have submitted from the submission of the Custodian board, they are saying plot number 24 was co-owned. The second statement, they are saying that from their records, the former owners never returned. All I think one returned. Then in your submission, I have said, you did not attach the purchase agreement. So we don't know where you bought from and what happened. Now that you are here, can you brief us on what took place as far as the purchase of this property is concerned?
Chairperson, can I answer that?
Please.
Thank you, Honorable.
Open the microphone.
No. Okay now?
Yeah.
Thank you so much. If you read the court judicial review, it deals with the ownership, it deals with the Custodian board, and the questions you're answering are all a part of the court ruling. So we submitted this, and also the State Attorney General was defending this case. If you look on yeah.
Dr. My concern is how you got the property. I don't see the argument here. Where is the argument?
It is in the ruling. If you go to the ruling.
Did you buy through the ruling or you bought from the owner?
The ruling came afterwards.
But before, I bought from who and how did you buy?
Maybe.
You see, the entire process of purchase was subject of the court matter.
Members.
How do you buy? How do you Because, Chair, why I'm concerned, in the first property, these are your documents. Doctor, I'm talking to you. Through Chair, I'm talking to you, Doctor. In the first document, the first property, you have submitted the sale agreement. How you purchase the property and even listed the owners. In the second property, you are not listing the original owner of the property where you get it from. And that is my concern as a committee member.
Chair.
Before you come in, Doctor, Honorable Violet.
Thank you, Chair. I just wanted to add on to what my colleague has asked. I wanted to ask Doctor, how did this case end up in court? How did you go to court so that you ended up with this ruling?
No.
This is a very good question because Custodian board wrote to us saying you are not the owner of the property. And the very essence of this ownership question raised by Custodian board, and that's why it ended up in court. And that's why I'm saying that the court, the case was subject of the ownership.
So did you approve your ownership to Custodian board by presenting the receipts that will indicate that you have the right to?
That's what the Right Honorable, that's what the court decided. If you look at the judgment, the judgment is the very essence about the ownership of the property.
But what makes it difficult to say you have bought the property?
You see, members, where the court came up with as the judge on a decision, where the court has pronounced itself on a decision, you can only challenge that in court. That's the principle. Two, I also have a reservation on the judicial review giving ownership. I also have a reservation on different because on the thing, but we are going to make a report. Having got whatever we've got from all those sites, at the end of the day, we are going to make a report as a committee.
Yeah, thank you, Chair.
Yes.
Chair.
Yes.
Doctor, this court, the court documents you have submitted, when you come from page 1, there is no page 2. You go to page 3. From page 3, you go to page 5. From page 7. I don't know if this is the...
Members, we have the capacity to get that judgment. We have the capacity to get that judgment. And our legal counsel, we can task our legal counsel to get us that judgment and pass it over to our clerk to make copies for all members, so that by the time we shall be making our report, we would have enriched ourselves with the judgment. Let's go one by one. Honorable Itungo, Honorable Barrett, Honorable Kahonda, then Honorable Sowanyana, we conclude on that matter.
Thank you, Chair. Chair, I want you to compare what I'm reading and maybe the copy they have submitted, whether it is a mistake or it was deliberate. When you look at the court documents, the way they have filed these documents, the pages, from page 1, there is no page 2. So the information on page 2, we don't have it. From page 3, we got page 5. The information on page 4, we don't have it. From page 5, we got page 7. The information is not there. From 7, we got 9. So that means now we cannot follow what we are doing that.
Therefore, Chair, we then proceeded well. If some information is lacking, the question is, would it have been deliberate that we are not given this information so that we ask rightful questions?
Doctor?
Chairperson, we can resubmit the whole ruling.
The question is, this is your document which you have submitted before the committee, and you include a very pertinent issue which can help us resolve this matter. That was the case, the judgment. And when you read what members observed, the judgment you submitted before this committee is not in full. When you go page 1, then you jump to page 3, page 3. So members are concerned on what was included in those skipped pages, so that they can have a situation where they can make an informed view.
Actually, Mr. Chair, when you refer to page 15, I don't see the part of the ruling, but I can see where they are saying that he had bought the property 2 times, first from Greenland, and then there is a coffee marketing board. So we need to, that is on page 15. Those are the things that we need to understand.
Members, something which can go solve this. Our legal counsel, the committee has ordered for the judgment. They are bringing the copies. I suggest that we stay this matter until the judgment comes. We proceed to another.
Chair, I have one for the custodian board.
There is no way on this.
No, not on the judgment. But I want to clarification from custodian board. When did the repossession process end?
Honorable Kaponda, yes. Even if you ask, we are not going to conclude this matter. We stay this matter until we get the judgment, then we can proceed.
This is outside the court matter. When did the repossession process end?
Honorable Chair, the repossession process ended in October 1983.
1993. When did the owner of this property repossess this property, particular property?
Honorable Kaponda,
yes.
We have agreed in principle. Let them first bring the case, which our legal counsel.
Yeah, but you see, Mr. Chairman, why I'm raising this particular matter
is, when the document comes, we are going to revisit this property today to its conclusion. Yes. Instead of going when we are not going to conclude it, let's go for another property as we are waiting for the document to come. Then we revisit this matter and we conclude on it.
Yeah, I agree with you, Mr. Chairman, but it can also be on the record that since the secretary is saying the repossession process ended in 1993, it is noted that this property was repossessed, purported to be repossessed on 5th of April 1995.
So, point noted, Executive Secretary, when we go back to that, we go back to this property, you answer that question. Let's proceed to another property. Let's go to another property.
Mr. Chairman, is number 3.
3. It also has a blue folder here. When you click on your blue folder, the issues you didn't put the plot number 3 Bombo Road, Kampala. It has 3 annexures enclosed. I mean 3 documents enclosed as part of the annexure. And the witness can give us his views on the matter.
Regarding Clause 3 Bomber Road, documents enclosed are as per Annex C. Such reports showing their investment as a registered proprietor, new cycle after conversion. And these will register model showing their investment as a buyer from joint venture Uganda Limited.
Custodian board.
Honorable Chair, this property is comprised in plot 3, block 38, area 188, 424. This is a property which was advertised for sale by the Party Resident Property Concern Board under statutory instrument, number 17 of 1995. And we don't have any record showing that this property was dealt with by the Ministry of Finance by way of disposal as per this statutory instrument.
What is the effect of that?
Honorable Chair, this statutory instrument of 1995, number 17, provides that where a property remains unsold after having been offered for sale in accordance with paragraph 2 of this order, the property shall be re-offered for sale for as many times as the concerned board divestiture committee shall determine until it is eventually sold. And Honorable Chair, after constituting the divestiture committee, we have submitted to the board of valuers to deal in this property in accordance with the law, unless otherwise.
Do you have the mother title?
Honorable Chair, we have the duplicate certificate of title, but we also we have searched. We have to conduct a search so that we can have the process concluded.
Just a second. Are you saying you've presented to the board a sale of property whose search you hadn't conducted?
Honorable Chair, this is a statutory instrument of 1995.
No, I'm only asking you. You respond as asked. You said you've conducted a search. You're conducting a search. You've not yet conducted a search. But in your submission, you've told us you've presented it to the Board of Valuers to value and sell it.
Obviously.
Without a search.
Honorable Chair, this is an existing document.
No. Please, sir, you're conducting the search and help everyone understand. Okay? You said you presented this property for sale. All right? The presumption is you have the title in the names of the departed agent who was then Udaka Ginas, because we are looking at the title amongst our annexures here. Is that right?
Yes.
And on your title, it has never been transferred from Udaka Ginas to any other person?
Yes.
And therefore you put it up for sale. Can we take that as a record?
That's what it was. Yes, it was.
So what search are you conducting?
Honorable Chair, administratively, we have to undergo so many processes to complete the process.
Honorable Lady Council.
The title before us, Mr. Chair, shows that he has presented, and now these questions go to you, Dr. Sudhir. The Custodian Board says this property is still under Budaka Ginas in the title they have before them, and I pray that they submit a copy of it to us. And the one you've given us shows that in 1996, MK Investments Limited had this title transferred to it. Then Joint Venture Uganda Limited in 2004, and then 2004 to Mera. I'm struggling to look for a repossession certificate registered on this property from what you've given. The presumption should have been that a repossession certificate should have been registered on the copy of the title amongst the instruments entered. Do you find anything missing on your title?
Microphone.
We went to the register of title, we checked who was the registered proprietor, and we found them joint venture to be the legitimate registered proprietor, and we bought it from them.
Members, I think for purposes of clarity and follow-up, if you can allow me, because the person who wrote this narrative is here, we need, if I can read verbatively, then he comes in to tell us how he reached this narrative. He wrote a field report on plot 3 and 5 Bombo Road, LRV 205 4011. The property is situated on Bombo Road after Shua House. It is a flat with old structure, and the property is currently occupied with tenants of Mela Investments. By 1972, before the expulsion of Indians in Uganda by the military regime of President Idi Amin, the registered proprietor on the land title was in the names of Budaka Ginas Limited, P.O. Box 366 Mbale. The property is among the expropriated property with a running lease of 99 years from 1946. By the time of Exodus in 1972, the company of Budaka Ginas had only used 26 years of lease, leaving the balance of 73 years frozen lease. It is upon the balance of 73 years that the Custodian Board is managing until the minister responsible deals with the property accordingly. It is not on the record that proprietors of Budaka Ginas did physical return to Uganda to reclaim the properties in the country. Why? So the property reverted back to the controlling authority, that is the park. As a result of the transfers on the land title was done in Ella by the register of titles in the Ministry of Lands. This means once the Minister of Finance has not dealt with the property will have a running lease of 73 years from the date of Exodus. There are no registered instruments on the land title to indicate that once the property was dealt with by the responsible Minister of Finance, as the Council had asked, all transactions from 1996 to 2004 by 3 companies, namely MK Investments Limited, Joint Venture Uganda Limited, Mela Investment, was registered in Ella, should be cancelled by the register of companies. This was the narrative was written to this committee by Kamugisha Leonard, Liaison Officer, Central and Western Region, and is here before us. What made you to write such this narrative?
Chair,
please speak on the mic. We want to hear.
My work is to coordinate the worker from the field to the management. When I checked on this property, I find it is an expropriated property of which has got a running lease of 99 years. And there was we could call it a frozen
Speak
lease.
up for members to know. Speak like that.
So I found that the property has got 99 years, of which the former owner had only used part, and part was still remaining. until the Minister of Finance deals with the property, those remaining balance of the lease continue until has done it. And I do not see any certificate of repossession and all the certificate of purchase on the property. Secondly, to make it worse, the property was transferred. Was transferred from lease to freehold, as I talk now on the record. So there is another land title that has come out, killing the other information of which Custodian board can be able to face this.
If I may ask you, having discovered that the occupants of that plot is Bella Investment, did you take time to write to them to inform them that this property belongs to Custodian board?
My work, sir, I normally report to management, then management acts.
Executive Secretary, did you do that?
Honorable Chair, that is another side of the information. But my mainstream information is the statutory instrument which I'm having. And this is a statutory instrument that was put public, and whoever dealt in this property was bound to make due diligence, and this is a public document that has run from 1995 to date. So until otherwise, if anybody rebuts this, it remains in existence.
You see, Executive Secretary, I think it should be a practice, because if you sit based on that the document, that's true, the document's there, but should also inform Ugandans not to spend their money on things which really belongs to Custodian board. To me, I would think it would be prudent to inform the occupants of the plot that this plot belongs to Custodian board, so that he can't go ahead in developing the plot when he knows the plot is not his, or the property doesn't belong to him. Either he comes back and regularizes. In such a situation that the thing is still there, really, you need to change your practice.
Mr. Chairman, maybe I had a simple intervention to make. On the board of the custodian board is comprised of the Minister for Lands. And therefore you have unlimited access to the register of titles. Having known and ascertained this information, did you make any attempt to write to the register of titles challenging the person who was in occupation of this property? Because this is the beginning of a challenge. Because mere gazette does not, of 1995, does not challenge or impeach a title. The only person with the powers to impeach a title is either court or the registrar of titles. And that's why, Mr. Chairman, when Honorable Muru presented that it would be prudent that in future meetings we have the registrar of titles here and the Minister for Lands, like we had initially done. But in any case, it's just a yes or no question. Did you, after having ascertained this information, did you alert the registrar of titles?
No.
You did not? Okay.
Equally, honorable member, through Honour Chair, neither did the Minister of Lands tried to find out when they were dealing that property, if it is under our management.
Executive Secretary, I have a letter written by Sala Kulata to Custodian Board, copy to the Minister of Finance, asking the Minister of Finance and Custodian Board to submit all the Custodian Board properties to Minister of Lands, so that before they proceed with the transactions within the custodian, they know which property. I have that letter before me, written by Betka, because there was a first letter which was written by Betka Simbazi, then to the Minister, to the Minister of Lands, which was referred to Sala Kulata, and Sala Kulata wrote to Custodian Board. Have you come across of that letter?
I did.
Did you submit those documents to the land?
Information Chair.
Yes, sir.
All government entities, through the members of the board, by design, that they are supposed to deal in these properties, they have all the statutory instruments.
So, for you, at the conclusion of this matter, that property still belongs to Custodian Board?
Yes.
Chair.
Members?
Chair. Chair.
Honorable Itungo.
Thank you, Chairman. Doctor.
We shall make our recommendation on the same.
Doctor, on your submission, the same plot number 3 Bombo Road. In your submission, the documents you have submitted, there is no sale agreement. And why I'm insisting on these sale agreements, would see the parties where you bought from. For example, they are saying that the former owners are. Doctor, I'm submitting. Doctor, I'm saying that this document you have submitted, you have not attached the copy of agreement, the sale agreement. And why we are interested in the sale agreements, you hear what the Custodian Board is saying. They are saying that the former owners were Dakajinas. Maybe if we had your sale agreement, we would see whom did you buy from. So why didn't you attach the sale agreement on this very plot, Mr. Chair?
So, members, you know why we still have...
Give Doctor the chance to answer, Chair. Maybe.
Honorable, we purchased this from joint venture. The people we bought it from the joint venture limited. He was a registered proprietor before us.
Chair.
Honorable Violet.
Yeah, thank you, Chair. I think that the concern of the member is the purchasing agreement is not attached. As a new just informing us, is it so hard for us to have the copy of the purchasing agreement so that we can as well acquaint ourselves with it?
You see...
So the concern does not be responded to.
No,
where is the
Chair.
purchasing agreement?
Chair, he's going to respond. Let's Honorable Panado comes in, then he responds.
I vividly recall when we went with you and other colleagues of ours in Canada, there is a gentleman from the Budaka family, Budaka Jinas, who attested that he can even come back and be examined on the same floor, but it's later because of this lockdown. Maybe when Dr. Sudhir reappears back, I think on 7, we can even play him that video. Because it is on record, he can get it and get all the this is where the gentleman claims everything. And they have the original certificate of that plot. But I think because of these kind of humans, we have it.
Dr. Sudhir.
First of all, before I acquired, we did a transfer to the land office. Anybody can do a search and find his documents. Second thing, we never bought it from Dhaka. We bought it from joint venture. Right?
You see, Doctor, what this one is helping you because under the Expropriated Properties Act, whenever the fraud is realized at the start of the transaction, that means all the subsequent transactions are now unvoid. Now, what we need from all this, which the committee will make a decision on, that the person who did repossess this property, repossessed it wrongly. But there is Dr. Sudhir who did a research and found that that person, MK something, joint venture something, was on the face of the title. That means did a due diligence for him to buy that property. So the committee will sit and take a decision based on the two issues on that. Because for the issue of Bombo, Plot 5 and Plot 3 and 5, Bombo Road, indeed we got someone who was claiming that those who dealt in this property, they dealt in it wrongly. We have videos, we have what, he brought all his documents reclaiming this property. So, but the committee will sit and take a decision. Members,
Mr. Chairman,
we had stayed Plot 24.
Yes. Mr. Chairman, I have one.
But we had stayed Plot 24.
Yeah, but
let's proceed.
Now that we are on this, Mr. Chairman, I request that I put it to Custodian Board because they are giving us.
Proceed.
Thank you, Mr. Chair. They are giving us contradicting information. Because from their submission, the document that they presented to the committee, Mr. Chairman, they presented a list of properties issued with the repossession certificates. And I can see serial number 877, Budaka Guinness Limited. It was issued with a repossession certificate, certificate number 0708 on 24th June 1991. And from the information the Executive Secretary is giving us is that this property was not repossessed. Maybe we need clarification on this matter.
Custodian Board.
Honorable Chair and honorable members, as I alluded to the same issue earlier on, the repossession process it must be conclusive. Where there is a non-return, there is physical return. Whereas repossession was authorized, there could have been some other process that were not alluded to, like a physical return, and that could be. That's why it was put under this statutory instrument for disposal. So as the chair puts it correctly, we need to dig deep and find out the real facts.
So should we take it that not all the information that you submitted to the committee is correct?
Well, it's correct because it's true the certificate of repossession was issued, but it could also be correct that who was assigned to repossess never returned. To repossess physically.
Kamgisha, then Honorable Muiru.
Chairman, through the Executive Secretary, at times it is by law, according to the expropriated Act of 1982, it says somebody can come in and repossess, but if he failed physically to come and return and manage the property may be returned back to the controlling authority. So according to the report that the Budaka Gina not physically come here to repossess the property. So on that ground, the board have a right to go back, the property go back.
Honorable Muiru, then we conclude on this.
Thank you, Mr. Chairman. Mr. Chairman, listen, I just want to contextualize in light of what the Executive Secretary is saying. You see, to me there are two issues. First, whether the property was expropriated. And that one we have agreed that this property was expropriated, therefore it fell under the Expropriated Properties Act. The next issue is whether the property was dealt in by the minister, either by issuing a certificate of repossession or a certificate of purchase. And from the certificate number which Honorable Kawana has read, you understand, it's like there's a certificate. What we want you to help the committee is to vitiate the process of repossession. You understand? Because once you vitiate it, which cannot be a statement of opinion, it has to be a statement of evidence, a procedure of evidence, so to show us that according to whoever was returning to repossess, either would submit a copy of his passport, he would do this, according to this one. This is not, because you see, for us, if you are a doctor, when you're saying, I did repossess from this opening statement, I bought from someone, that's why I found the demand by Honorable to valid. The doctor, if you are saying you bought, was it verbal? If it is not verbal, then furnish us with evidence of buying, so that we don't link you to these people. But in the absence of any evidence that actually you bought, what remain in my mind, that you are part of EMOCA, you are part of joint venture, and you have metamorphosed into MERA investment. That's why as a committee we are saying, you submit the evidence, but for the purpose of on our part, I think that Mr. Chairman, the Custodian Board should help us to show this process of repossession. If it was not complete, what do we base on to conclude on that?
Honorable Member, if I can collect a bit. On the title before us, there is no entry of any certificate of repossession on that. So that one you should note it. So there, Honorable Panado.
Chair.
Then Honorable Itongo.
Chair, if it is in the interest of the committee and in the interest of all of us, maybe when Dr. Sudhir appears on 7, we should play that video, and you even have other supportive documents on top of that, on that file, because even Mr. Viziwaika can also attest to that, that he was also there when those people were presenting all their facts. In fact, one of them said that by then, Emukakato, when he came back to Uganda, Emukakato threatened him with a gun. And I think he was escorted, you see, this police of yours. And there is a way they handled it, and then he left Uganda and someone else. But he tried to come back, and he's still insisting he can come back just because of this lockdown. He can come back and test everything that plot belongs to him. And he has all the supportive documents and originals. And even the photocopies they gave us, we are also seeing the originals. You have that video with you, and I also have a copy of the video with you.
Honorable Itungo.
Thank you, Chair. Chair, you know you gave me an assignment on this plot, and I've been doing my research. That's why I'm insisting that the doctor should submit the copy of your sale agreement so that we can compare what we have and what you actually have. Otherwise, if you don't give us an evidence, then our work becomes very difficult.
So we therefore elect doctor to submit the relevant documents, which include the sales agreement for this committee, so that they can also get to reach the conclusion with the informed view on 8th July 2020. We just submit the document. When we peruse through, if you'll be needed to appear again, then we can let you know. But you submit the documents to our clerk. Members, you are wanted. I think all of you are in. Let us reverse report 24, which most of you we wanted to the missing pages, and now I believe that all of you are in possession of the judgment. Yeah. Now you can ask whatever question you want to ask based on the judgment. And you submit this, putting it in mind that the court had already ruled on this, and the custodian board never appealed. I don't know whether they're out of time or they can do anything, but you are submitting that. We are discussing that just as a point of advice, not to overdo what the court has ruled. Members, you have the judgment before you. You wanted it, and you had some questions you wanted to ask. You can proceed.
Doctor, page 15.
Page
15 of the judgment.
15 of the judgment.
The last paragraph, Chair.
No, for purposes of justice, but we can't undo anything here.
Doctor, just a quick one. You remember I was asking about how you bought this property, and you said everything was in the judgment. Now, when you read the last paragraph of the judgment,
you see,
you are there, Doctor.
Excuse me, procedure. Your procedure takes precedence.
Chair, we will not be proceeding right when we can come back here and we start reviewing the judgment of the High Court. No. Maybe we can go to another item. Yes, we can. You know, ours only to look at the judgment, analyze and interest ourselves in it, but not.
Mr. Chairman, maybe addition. Honorable Itungo, just a second. I am in good faith. As servants of God, with the principle of separation of powers, I don't know what would be the effect of reading the court judgment Are we going to throw in our opinions? Are we going to challenge the opinion of the judge? And the issue is, we can vest this in our report to say, if we so wish, that maybe the board erred in not making an appeal based on the following merits. But starting to audit a judgment of court defeats the principle of separation of powers from its onset. And I don't believe any of us wants to object to that. Even if you're objecting in good faith, it is not right. We asked for all the pages, and all the pages, the question was, why were there missing pages? And now all the pages of the judgment have been presented. And if you want to interest yourself in what the judgment says, you go into the conclusion on page 16, and you'll get the effect of the judgment. Then we can wait for our report on
members, before I go on that, let me invite our legal counsel to the committee. Let me invite our legal counsel to the committee to give us advice on this.
Thank you, Chairman. As already alluded to, this matter was subject to legal dispute in Land Division Cause number 16 of 2012. It was determined on 20th December 2012. It was a judgment of court, and in this ruling, because it was an application for judicial review, number 3, they clearly declare who the lawful owner is, and in the absence of a satisfactory appeal having been filed and decided, then that remains the position of the law. It requires that you can probably read it for informative value, but you cannot try to open a judgment. We've got 2 decisions on that. Barikove Jamada versus Attorney General, and Ali Sekatawa versus Attorney General. So, Honorable Chairman, I would advise that we drop this particular matter because we cannot sit in appeal on a matter decided on by the High Court.
Members, I think
You see, Chair.
Chair,
for once, you listen to me, Chair.
On this, I just want to know, you are submitting on which one? On the judgment?
Chair, you listen to my submission.
My question is, are you submitting on the judgment, Honorable Member?
Chair,
no, we don't want to seem to be doing right.
Chair, the procedure, it is just a quick
Wait,
one,
you don't want to seem to be doing right when we are doing wrong.
No, Chair, it is just a procedure matter, Chair.
What procedure?
Now, Chair,
procedure.
This committee is on record. It's an accountability committee.
Yes.
When we are handling these properties,
yes,
in our report we shall say, we dealt in this property, there is this evidence, we don't have any issue on it.
Yes. No, we don't have any issue. Because custodian board, they ought to appeal. They did appeal.
So, Chair, that is not our concern, Chair, as a committee.
It's our concern.
If it is our concern, Chair, that's why I was making an observation in this judgment, that if it is the opinion of our legal counsel that we should not waste a lot of time on this property, we leave it and we have the judgment that gives powers not to deal in this property as a committee. Just for that, for accountability purposes, Chair.
You see, Honorable, we all have reservations. Surprisingly, one of my lecturers who taught me civil is before me here. I have some reservations on this, but this is a court ruling. You can only air out your reservations if you go back to court, which custodian board did do. So as Parliament, we don't have powers to review the judgment of a court.
And Honorable Chair, just for matter of emphasis for my senior comrade and colleague, a court decision, whether bad or good, whether faithless or hurting, can only be vied by another decision of an upper court. It's not bad.
And members, Honorable Itungo and members, this is not the final discussion. We are going to write a report So reserve all your comments on this. We shall include it in our report. Next property.
Honorable Chair, now we, having concluded the requirements of what this committee has asked, we can now move to number 5, Bombo Road. We had 3 and 5 are the same? No. The same issues? Okay.
43.
Now we can move to 43 Ginger Road. The floor is yours now. 43 Ginger Road. The green annex.
Before you proceed, members, I think we should be attentive and follow. Because I'm seeing as if you have different meetings in one meeting, so let's come together and move at the same page.
Chair.
Yes, sir.
The documents for plot number 5 Bombo Road.
Plot?
Plot 5 Bombo Road. Because we have finished plot 3, now we're supposed to go on plot 5, but I think it is the same, we bought from the same person. So do we wait for the documents that you can...
Comrade, if you look at all those the titles, both plots belongs to one people. So that is one company, that's Dakatinas. So we have handled that, so we shall follow that, Dakatinas, both of them. So, Doctor, can present 43.
Thank you, Chairman Honorable. The document enclosed as Annexure E on 43 Ginger Road, Kampala. 1. Search report showing Bira Investment as a registered proprietor. 2. Freehold title after conversion. 3. Leasehold register volume showing Bira Investment Limited, the buyer from Star Insurance Company.
Custodian board.
Allow me present what is exactly on file. Honorable Chair, this is a property comprised in plot 43, LRV This is comprised in plot 43, Kampala, Ginger Road. At the time of expropriation, this property was
wait a bit. Members, let us listen to what they are submitting, then we can be able to make an informed view.
Was owned by Abdul Ghani and Abdul Majid, both of PO Box 274 Kampala, as tenants and in common equal shares. Honorable Chair and members, application to the possess was submitted and £50 was paid. And Honorable Chair, on the 21st January 1993, this property was repossessed and the certificate authorizing repossession number 1301 was issued. And Honorable Chair, this particular property, according to what I have on file, Abdul Ghani registered a certificate of repossession as provided for in the law, and it is registered on 16th May 1991 at 3:30 p.m. under instrument number 270550. Then after registering the certificate of repossession on title, Abdul Ghani was entered on the certificate. Thereafter, in 1995, Abdul Ghani sold the property to
Executive Secretary, let's go through. That was a property which was tenancy in common, not so?
Yes.
What does that mean? That you must, what I want you to show us, that both parties, they did repossess, and we proceed like that, and we...
Honorable Chair, according to our certificate of repossession, it was Ghani and Abdul Majid who were the former proprietors. That one tallies very well.
Repossession.
Then at the time of repossession, they are the ones who repossessed.
Both.
Then also, the registered certificate of repossession on title bears the same. Also, the cancellation of the entry in 1995 on 16th May bears the same. And here is the cancellation of the entry where they had sold to Gold Star Insurance Company. Then in 2001, they transferred to Mera Investment Limited. So, Honorable Chair, according to this record, unless advised and without prejudice, I would confer that this property does not fall under the ambits of the departed residence property custodian board.
Yeah.
So, in your opinion,
I still have some questions with the Executive Secretary. Executive Secretary, yesterday, on 26 June, because, you know, when people are complaining that custodian board is a confusing agency, all those who have been complaining custodian board is a confusing agency. When they are writing their things, this one writes another one and the other one writes another one. So at the end of the day, you fail to reach the conclusion of the whole issue. I have a document which was written to me by Dr. Yakatonda, giving the narrative of the same property. Can you read your document for members to hear? Then you collect it with what the Executive Secretary has submitted for this.
Honorable Chair, thank you. You did instruct me to furnish you with information relating to plot.
So were you misleading the committee? I want you to go on a conclusion. You and him, who is misleading the committee?
I think that's what should be sorted out. Honorable Chair, I stand by my write-up. I stand by my letter and I will adduce evidence. Honorable Chair, plot 4717, follow 12, Ginger Road. This property was formerly owned by Abdul Gandhi and Abdul Majid as tenants in the common in equal shares at the date of expropriation. According to records, there is no indication that the bill came back to validly repossess the property.
Since now we have two adult contradicting individuals, colleagues of ours who have told us, maybe they can go on oath because he gave you the letter, he has owned it, let him take an oath, and then he testifies on oath. Yes, because he can disown it again. Because he's saying the executive director has said a different statement, is giving us a different scenario. The witnesses before us have a different opinion. Then we will make a different judgment. Let them go on oath for recording purposes.
Members, I've left with no choice. Because when you come before this committee, and I believe that custodian board members, they always sit as a team. We invite them to appear before this committee as a technical people who can ably advise this committee as we are interrogating our witnesses. It's quite defeating my understanding that the two individuals within one agency, they can come before this committee and submit different views pertaining a property, where I believe they know either they want the name of the committee to be tarnished, that they are moving on, because they would have given that information long before, and you wouldn't have disturbed the doctor for the same. I therefore think that one of them is telling this committee some lies. So to get the facts from both of them, I would concur with what Honorable Panado has suggested. I therefore direct the clerk to put executive director and the chairman, the Investor Committee on oath. Thereafter I proceed. Thank you. As the 2 minutes have given it to you, go and bring the document, you administer that oath and proceed.
We can relax for some 5 minutes and
Members and our witness, you can relax, you can have something to do. Whatever is here is for all of us, but what we need is to solve this matter and for the good of all of us, because it's not good to go when you don't know which is which from the same entity. Thank you.